mention it before me, unnecessarily I will reject the mentioning. You have to give all the slip, put your date, take the consent. I can assure listing. I cannot say whether the case will be actually taken up or not. That much I can tell you. Then on the date when it is listed, you can just have a mention. If there is any urgency, it can be posted on the next day. What is the urgency? Sorry? Counter affidavit filed?
Yes, counter filed, rejoinder has been filed.
There is an adverse order against you, or you are seeking a mandamus?
I am seeking mandamus.
Have they opposed your prayer?
Yes, ma'am.
Have they opposed your prayer in the counter affidavit?
No, they are not. They are some one paragraph they are opposed, but my MSCP has not been granted. That's why I started that. First MSCP has been already granted, and that's why after that it has been reverted. Then I am filing the petition.
Just put it tomorrow. Tomorrow.
From supplementary list, permission item 2, WPL 800 of 2022.
Yesterday also you had paid for adjournment. Isn't it?
Only a short pass.
1 o'clock.
Item 3, WPL 3233 of 2022.
This case, challenge the award passed by the Labour Court matter by the presiding of Labour Court Ranchi under working commercial. The facts of the case is that manner. A person fell down while repairing electric wire metal and subsequently he died. The successors of the person has claimed compulsion of working compulsion and that has been allowed. Our contention is that before the presiding officer also we have been contesting that there is no relationship of employer and employee. They have failed to produce a single sheet of paper. May I please the award?
Workman compensation and yes.
May I please the award? The applicant above name being wife of the deceased, the wife of the deceased before
You want to read the entire award? You read the
that
relevant
is so,
portion.
That is so, my lord. How, despite our objection, my lord, they have not produced a single thing. And again, and the judgment is against the weight of evidence. Initially, this case was filed on 29th September 2007 in the court of the Deputy Labour Commissioner Ranchi and was assigned application number such and such, but later on Deputy Labour Commissioner by order date such and such sent the record to for favor of disposal. The record was received on such and such. The case of the applicant in short is that late Lakhan Kumar, alias Lakhan Mahato, was employed by the opposite party in the establishment as electrician helper since before 7 years. On 29th April 2007, Lakhan Kumar received personal injury by the accident arising out and in course of employment resulting in his death. According to the case of the claimant, on 29th April 2007, at about 3 p.m., the opposite party number 2 called to Lakhan Kumar, alias Lakhan Mahato, for repairing electric wire on electric pole at Chaurigram, Kanke, assuming that the electric line is off. The deceased Lakhan Kumar climbed to the pole and started repairing at the top, but suddenly electric was flowed in the wire and resulting that the Lakhan Kumar, the electric bulb, fell down on the ground and died on the spot. The occurrence of the accident was reported to Kanke Police Station on 30th of April 2007 by Ram Tahal Mahato, and on the basis of such report, Kanke Police registered case but not sent FIR to the court. The applicant was allegedly monthly salary of the deceased workman was 2400. and his age was about 42 years at the time of death. Further, the applicant and her 2 sons were dependent and deceased workmen. The applicant made demand of compensation from the opposite party, but it was not paid, and then she has filed the present case. The applicant has alleged death of her husband in course of his employment under opposite party as an electrician helper and paid for compensation from opposite party. The case of the opposite party, in short, is that the present case is false, frivolous, misconceived, and is not maintainable in the Workmen Compulsion Act. The applicant has got no locus standi to institute the above case against opposite parties. Further, the case of the opposite parties is that the applicant's husband Lakshman Kumar was never employed under any capacity in the Jharkhand State Electricity Board or erstwhile Bihar State Electricity Board. Since Lakshman Kumar, alias Lakshman Mahato, was not an employed electrician under the opposite party, the alleged contention of sustaining burn injury in course of his employment is entirely false and frivolous statement. The opposite parties are not responsible for any alleged accident which took place with Lakshman Kumar alias Lakshman Mahato. If there had been any such occurrence, the said Lakshman Mahato himself was responsible for the same. Further case of the opposite party is that opposite party number 1 has got his full establishment for maintenance of electrical lines, and thus under no stretch of imagination it can be inferred that applicant's husband was called for repair of the line. May I place the findings? Findings start with disposal of issue number 2. The issues are, there are 4 issues, whether the claim of the applicant is maintainable, whether the deceased husband died due to an accident, whether the applicant is entitled to any compensation, if so, from what and what extent, whether the applicant is entitled for any. The issue regarding employer and employee has not been said. However, while discussing issue number 3, that issue has also been. Disposal of issue number 2. The issue number 2 is whether the deceased died due to an accident. This is not disputed matter. There was an accident, an employee died, we are cause of death, we are not disputing. So I will not take the lawsuit for this issue. Disposal of issue number 3. Whether the applicant is entitled to any compensation. This will be the most important. For disposal of this issue, it is necessary to be determined whether the deceased was workman employed under opposite party and injury to him was caused by accident arising out of and in course of his employment under opposite party. That is it. Internal basics. The case of the applicant is that deceased was employed since before 7 years before the death, before accident or death in the establishment of the opposite party as an electrician helper. The opposite parties have denied such employment of the deceased and further denied his employment in any capacity under Jharkhand State Electricity Board and stated that the deceased was not an employee or an electrician and injury to him was not in course of employment. Admittedly, no written appointment letter of the deceased has been brought on the case record, and further there is no document showing payment of wages, object salary, etc. to the deceased by Jharkhand State Electricity Board, but for application of provision of Workmen Compulsion Act, no written appointment letter is required. If any other evidence, relationship of employer and employee between the deceased and OP are established and proved, Section 2(1)(n) of the Workmen Compulsion Act defines workman as under such and such. But we are not denying the definition, but we say that not a single sheet of paper has been produced. Therefore, para 14. Under the definition of workman under this act, there is no requirement of permanent employment as well as written appointment. And mere a contract of employment, whether expressed or implied, oral or writing, employed in the work in any capacity shown in Schedule 2 of the Act is sufficient. In Schedule 2 of the Act, list of persons who are subject to the provision of Section 2(1)(n) are included in this definition of workman has been given, and subclause 9 of the list of persons employed in setting up, maintaining, repairing, or taking down any telegraph or telephone line or post or any overhead electric line or cable or post or standard or fitting and fixture for the same are included.
This is at page number 7. You read this at page number 7.
Yes, ma'am. Now I am at page 8.
Just a moment. Yes, Schedule 2.
In Schedule 2 of the Act, this one. In para 16, further definition of employer has been provided under Section 2(e) of the Workmen Employees Compulsion Act 1923, which includes anybody or person, whether incorporated or not, and any managing agent or an employer, and the legal representative of a deceased employer, and then the servicer of the employee or temporarily lent or let on hire to another person by the person with whom the employee has entered into a contract of service or apprenticeship means such other person while the employee is working for him. Here there is no contract, no. Under section 2F, a managing agent means any person. I'll skip that matter. In this para 17, in this case, OP number 1 is Jharkhand State Electricity Board, and OP number 2 is subdivision of the Kanke Electric Subdivision under the Jharkhand State Electricity Board. Therefore, OP number 2, employed to any person for managing trade and business. Of OP number 1, then OP number 2 shall be the employer under this definition of it. Honorable High Court of Andhra Pradesh in such and such has held that even then, it should not be relevant.
It is irrelevant.
No, we are not. We say that even we go to the extent of saying that even a casual employee would be entitled to compensation. They have failed to produce any piece of contract implied, oral, anything, madam, to the effect that there was any contract, madam, engaging his services as a workman. There is nothing on it. Para 20 I will test, madam. That is the question of the workman. In the light of our discussion on perusal of oral as well as documentary evidence brought on record, I find that CW1, Mahesh Kachhap, has stated that he is electrician Bijli Mistri under the Jharkhand State Electricity Board as substation electricity company. In para 7 and 8 of his cross-examination, this witness has stated that he has identity card issued by Electricity Board to which he can file in the board. In the instant case, even the identity card has not. However, in para 17 of cross-examination, this witness has stated that he is not a regular employee of Electricity Board but renders his services according to need of the board and gets salary for the months in which he works. In para 14 of the cross-examination, he stated that junior engineer and electricity engineer Kanke used to employ this witness and others for work of electricity department. There is no suggestion to this witness that he was never employed as junior engineer and electrical engineer Kanke for doing work of electricity department. Therefore, from the evidence of this witness, we established that junior engineer and assistant engineer of electricity board Kanke were employing private electrician also for the trade and business of the board. Let me presume that yes, we were employing, but he has not produced a single paper showing payment or engagement of service or identity card. This witness also says, my lord, that I have an identity card which I can produce in. Further, my lord, in para 1, 3, 5 and 6 of examination in chief, PW1 has reported that Lakhan Kumar was posted as a guard in electricity board Kanke Anchal, but he was
You
doing
just
work
tell us one thing.
Pardon?
PW2 had no, the respondent number 2 had engaged in.
No, we never.
Has he deposed before the court?
No, he was never examined, my lord.
Who will examine him?
He has not been.
He was the best person
He
to
was the
say.
best person. Ramnath Mahato was the best witness.
He has not been examined.
He has not been.
Right? The evidence has come that you have been engaging private persons to do
Yes,
your work.
but he also says, madam.
Just a moment. He also says, but he has not produced his I-card.
Yes, but he says that I used.
Maybe, but he was not a regular employee.
He is not a.
Right. So, electricity department has been using private persons to do the work. Right? Matter ends.
But the fact that he was employed.
Who would have said? Your employee would have said.
But it was his duty to
No,
prove
no,
it.
no.
The burden of proof.
No, no, no. The fact that he was engaged for the purposes of the factum of accident is not in dispute.
Factum of accident.
He said that he was working under the instruction of respondent number 2,
Yes, ma'am.
not in dispute, because respondent
that
number,
is-
just a moment, respondent number 2 has not come up before the court to say that I never engaged him. He was, when he himself is a party before the court,
Yes.
was it not his duty to depose before the court?
Yes, ma'am, that was an error, but that
And
will
then,
not. That will not
and
be
then,
this.
and then further. Why did you pay him?
We have not paid. We have
You
denied.
have paid
No, madam, we have denied.
10,000 rupees. You have paid.
10,000 we have denied it, madam. The-
No, no, no.
No, at one place he says 10,000, the wife says 3,000, and
Whatever it is,
not even a single penny. We have said that nothing.
she has not been cross-examined on that point. There is no cross-examination. This is recorded in the
But
appeal
madam,
order.
point of payment has not been proved.
It has been proved.
Payment by the board cannot be in cash, madam.
We do not know.
We-
You can do anything when you can engage private people to climb up the pole
No.
to do the needful and cover your risk.
We
Isn't it?
employ as a guard. The CW1 has said I was employed as a guard.
Whatever
The
it
duty
is.
of the
You
guard
see-
is not to repair.
You see, we are not here to evaluate the quantum of evidence. in absence of any perversity. There is no question of any.
There is perversity to the extent,
No perversity.
just a minute, to the extent that the relationship of employer and employee has not been established. There is not a single sheet of paper which will go to show that we have made any payment.
We'll consider it.
Pardon?
We will consider your submission.
Let the lower court record be called
Not
for.
required. Not required.
That would show the deposition.
Not
of the
required,
witness.
not required, because it is not your case that any of the deposition which has been recorded herein is incorrectly recorded. That is not your case.
We have said that. We have said that. Let me tell the deposition. We have said that.
No.
Many words we have said, but that we have never.
No, never employed is another thing. The recording, whatever has been done
Yes.
in this case, it is not your case that that it has been wrongly recorded. This was not the deposition. That is not your case.
Let the deposition come out. We'll
Not
show from the
required.
deposition itself.
Not required.
We'll show from the
Not
deposition
required
itself.
at all. Not required.
But may there are other witnesses also.
I have read it. Your case is, it is against the weight of evidence. It
Yes.
is not your case, it is a case of no evidence.
It's a case of no evidence.
Against the weight of evidence and no evidence are
It's
two
a case of
different.
no evidence. I stand corrected. It's a case of no evidence.
This is your specific case in the writ petition also.
Yes, that it's a case of no evidence. That is my petition also. That is my ground.
No. Your case is, it is against the weight of evidence.
Against the weight of evidence and no evidence produced.
No evidence and against the weight of evidence are two different things.
Two different things. We have said no evidence.
No. Para number 38 of your writ petition.
Yes.
And at the opening also you said it's a case of, it is against the weight of evidence.
Yes, madam. Again, I.
It is not your case, it's a case of no
It's
evidence.
a case of no evidence. I just saw from the deposition of the witnesses.
No, you just show this. This
I
should
saw-
be your ground.
This is only CW1, madam. Let us
This
go to
is your-
CW2 and CW3
Yes.
also,
You
madam.
read.
In para 1, 3, 5 and 6 of the examination in chief, PW1 has reported that Lakshman Kumar was posted as a guard in electricity depot, Karachi ka case, but he was doing work of engineering further. He has stated that Lakshman Kumar and his witnesses both were working in the department as an electrician. These witnesses reported on the day of accident, the deceased, as his usual work upon direction of Assistant Engineer Electricity Sri Ramnath Ram, was repairing electric wires and climbing electricity poles, and in that course he sustained injury by electrocution and tiredness. Therefore, PW1 has proved employment of the deceased in the department for doing work. He has proved only by orally.
That's enough.
Murdered. Only my mere saying that he was employed will not prove that I stood employed. He has to show it from evidence. He says that I have identity card which I can produce in court. But the petitioner hearing, the petitioner before the court presiding officer, my lord, has not produced any identity card of that sort to show that he was ever employed in the
Therefore, you are also issuing identity card to those persons who are not your direct employees.
Yes, my lord. We are
Yes.
issuing,
Under what authority?
we only
Under what authority can you?
that identity card is by way of an entry pass, my lord, so that he can enter into the premises of the district court, my lord. But here he has failed to produce even that identity card. The mere you lordship may call it an entry pass.
Okay.
That has also not been produced.
That's
My lord. Further, my lord, this witness has reported that on the day of accident, the deceased Therefore, PW1 has proved the employment of the deceased in the department for doing work of electrician, and further proved that at the time of death of accident, the deceased was working under the direction of Assistant Engineer Sri Ramnath Ram. Although the witness has stated that deceased was getting payment of rupees 1,000 per month from security agency and not from the electricity board, you lost your receiver. But there is no variation in the evidence of witness on the point that the junior engineer and electrical engineer of electricity board Kanke were employing private electrician. The deceased also was employed for the work of electrician. The time of accident, the deceased was doing repairing work of electricity wire upon direction of the then assistant engineer electricity, namely Sri Ramnath. PW2, Ram Prasad Mahato, also an electrician. This witness has reported that Lakhan Kumar was posted as a guard in the Jharkhand electricity board at Kanke, but he was used in doing work of electrician. Further, he reported that this witness and Lakhan Kumar both were doing work as electrician in the electricity board. He has reported that on 29th April 2007, while the deceased was repairing electricity wire upon direction of Assistant Engineer Sri Ramnath Ram as usual, he received injuries by electrocution and died on the spot. PW2 has reported that monthly salary to workers were given by Assistant Engineer Ramnath Ram, and upon his instruction, work order in writing were issued. Work order in writing were issued. This witness has filed photocopy of one office order dated 20th of October 2004, which has been marked Exhibit 1. During cross-examination, this witness could not speak name of the scribe and the person who signed on Exhibit 1. This witness has denied this work order is with regard to PW2 matter, not with regard to the decision. This witness has denied knowing the year from which the deceased was employed in the electricity board, but stated that Lakhan Kumar was working since 2 to 3 years in the department since before his death. This witness has stated that after death of Lakhan Kumar, the electricity board has paid rupees 10,000, except that no other benefit has been given to the wife and family of the deceased. In para 13 of the cross-examination, this witness has reiterated version of his examination in chief and stated that on the day of accident, this witness was also employed with the deceased, but he was not present in the place of accident. The defense has suggested to the witness that Lakhan Kumar was never employed of the electricity board and never did work in the board, to which he denied. Further, this witness has denied suggestion of opposite parties that Exhibit 1 has not been issued by the department. There is no suggestion to this witness that he was never employed in the electricity board by the engineers of the department for doing work on the CW3. Shankar Mahato has deposed on the same line as has been deposed by CW1 and CW2. This witness also has deposed that he is a private electrician and employed with the deceased in the electricity board. Further, this witness has deposed that on the date of the accident, the deceased was repairing electricity wires by climbing on the pole upon direction of assistant engineer Ramnath Ram and sustained injuries by electrocution and died on the spot. This witness has reported that the then assistant engineer, namely Ramnath Ram, used to issue direction to work to employees and employees were getting payment accordingly. This witness has stated that news about death of the deceased in course of doing repairing of electricity wire was published in the daily newspaper Dainik Jagran. And according to report of the newspaper, the deceased was working since 7 years. What they are relying upon are newspaper publication. And according to report of the newspaper, deceased was working since 7 years in the electricity board before his death. This witness has reported that after death of Electrician Lakhan Kumar, the then superintending AR Singh had provided vehicle for taking the dead body to the house, and the electricity board has paid rupees 10,000 to the family for cremation of the dead body. This witness has stated that Lakhan Kumar was getting rupees 1,000 per month and he died in course of employment. During cross-examination, this witness has denied having any identity card of the department and stated that he can file salary receipts. Further, he denied any return. He said, I can file salary receipts. Salary receipt of the deceased has not been filed. Further, he denied any return order to Lakhan Mohammed on the day of accident for doing work in Chudi University. He denied his presence at the time of accident but stated going to the place of accident after the accident. The witness has denied any documentary proof with regard to providing vehicle for carrying the dead body and payment of rupees 10,000 by the department. The opposite parties have suggested this witness that Lakhan Kumar was never employed in the electricity department and died on his own fault, due to which this witness has denied. CW4 Ram Tahal Mahato is the son of the deceased. This witness has proved applicant's case on the point of employment of the deceased in the Jharkhand State Electricity Board as Kanke Anchal as guard, and further proved that the day and time of the accident deceased was doing work of electrician upon direction of Sri Ramnath Ram Electricity Engineer Electricity Kanke Ranchal. Further, he proves death of deceased by electrocution on the spot. This witness has further proved that assistant engineer Ramnath Ram used to employ the deceased and further he used to pay rupees 1,000 per month to deceased. In para 8, what is the Ramnath Ram used to do? In para 8, this witness has reported that the electricity board has provided vehicle of the department for carrying the dead body and the place of the accident to the house and paid with 3,000 cash for cremation of the dead body. Earlier it was 10,000, now it has been reduced to 3,000. The opposite parties have not cross-examined this witness, hence entire testimony of this witness is uncontroverted. CW5, the vice of the deceased. This witness has proved that her case at the length by saying that her husband was employed as guard in Jharkhand State Electricity Board. The board was taking his services as electrician. Further, she has reported that on the date of accident, her husband, as usual, was repairing wires of electric poles upon direction of Sri Ramnath Ram, and that in course of received injuries by electrocution and died on the spot. She has reported that the then SDO of Kanke Anchal has provided rupees 10,000 for cremation of the dead body. During cross-examination, this witness has stated that written paper of employment to her husband was issued and further stated that there was a written order for repairing and payment to which she can file in the court. But again, that has not been marked as an accident. This opposite party has suggested to this witness that deceased was not employee of the department to which she denied.
I have read the entire text.
Yes.
Reading will end the entire day.
No, it will not end the
Now you
entire
listen
debate. That
to
will prove my case, my lord. So,
That's
so far as the factor of
now you
employment-
listen to the order. WPL number 3233 of 2022.
And your lordship will one thing, before your lordship starts. Your lordship has seen yesterday when the order, the case of this is for default. Thereafter, my lord, there is
But you have participated throughout.
Yes, I participated subsequently.
That's
But there is nothing on record to show that the restoration application
That's
was filed and it was restored subsequent to an
That's
order of the court.
That's right. WPL number 3233 of 2022. This writ petition has been filed for the following relief. The learned counsel for the petitioner, by assailing the impugned order passed by while assailing the impugned order dated
Dated 30th of November 21.
30th of November 2021, has submitted that the impugned order is perverse and the finding recorded by the learned presiding officer, Labour Court Ranchi, that there was employer-employee relationship is based on no evidence. The learned counsel has submitted that neither any appointment letter was filed nor any document was filed to show that the petitioner ever made any review मत फाइल करिएगा फिर हम नहीं सुनेंगे because you are leaving the court in the midst of the dictation.
That correct.
रिव्यू मत फाइल करिएगा हम नहीं सुनेंगे. The learned counsel has submitted that the impugned order is perverse and the finding recorded by the learned court with regard to relationship of employer and employee is perverse, and in as much as no documentary evidence was produced to establish the relationship. The learned counsel has also submitted that there is neither any appointment letter nor any document to show any payment to the deceased person, and therefore no liability could be fastened upon the petitioner for the purposes of payment of compensation under Employees Compensation Act 1923. The learned counsel has raised an additional point by stating that the case was earlier dismissed for default by the learned court by the order dated 8/3/2016, and thereafter there has been no order for restoration, and ultimately the case proceeded and the impugned order has been passed. However, during the course of argument, it is not in dispute that the petitioner had participated in the proceedings and both the parties had laid evidence, contested the matter, resulting in passing of the impugned order. The learned counsel has placed the award, the impugned order, and has submitted that the petitioner is primarily aggrieved by the adjudication relating to issue number 3. After hearing the learned counsel for the petitioner and going through the impugned order, this court finds that the case of the applicant, in short, has been recorded in paragraph 3 of the impugned order, which is quoted as under, so far as the case of the opposite party number 2, that is Subdivisional Officer Kanke Electric Subdivision Jharkhand State Electricity Board, has been recorded. The case of the opposite parties have been recorded in paragraph 4, which is as follows. The impugned order reveals that the notices were issued to the opposite parties by the learned court, and in response to the notice, initially the opposite party number 2 had appeared and filed the show cause on 12/1/2011, and later on the opposite party number 1 appeared on 15/6/2011 and adopted the show cause filed by opposite party number 2. The records also indicate that the specific case of the claimant was that the opposite party number 2 had the deceased was doing the work of repair in the electrical line in the electricity line under the instructions of opposite party number 2. However, the records also reveal that opposite party number 2 never deposed before the learned court. On the basis of the pleadings of the parties, the following issues were framed. Paragraph number 5. The applicant, the wife of the deceased, examined altogether five witnesses, including herself as CW5, and as many as 6 documents were exhibited. The details of the persons who deposed as witness has been recorded in paragraph 6, which is as under. So far as the petitioner is concerned, only one witness, namely Mohammad Sabir Ansari, Assistant Engineer Electricity Supply Subdivision Kanke, was examined as OPW-1, and no documentary evidence was adduced on behalf of the present petitioners, who were the opposite parties before the learned court. The finding with regard to issue number Roman 2, that is whether the deceased died due to an accident, has been recorded from paragraph 8 to 11. The learned court recorded the finding after scrutinizing the materials on record in paragraph 9, 10 and 11 as follows. The counsel for the petitioner has not disputed the factum of the accident even during the course of hearing, and therefore there is no argument in connection with issue number 2 as decided by the learned court. So far as issue number 3 is concerned, which is the bone of contention, the learned court in paragraph 12 has recorded that in order to dispose of issue number 3, it was necessary to determine whether the deceased was workman/employed under opposite parties, and injury to him was caused by accident arising out of and in course of his employment under opposite parties. The learned court recorded that admittedly no written appointment letter of the deceased was brought on record, and there was no document showing payment of wages / salary etc. to the deceased by the Jharkhand State Electricity Board, and at the same time was of the view that for application of the provision of Workmen's Compensation Act, no written appointment letter is required if by other evidences relationship of employer and workman between the deceased and opposite parties are established and proved. The learned court took into consideration the definition of section 2 within bracket I within bracket N of Workmen Compensation Act, which stood prior to the Amendment Act number 45 of 2009, which defines the workman. Admittedly, the incident had taken place on 29/4/2007. The learned court, by referring to the definition of workman, was of the view that there was no requirement of permanent employment as well as written appointment letter, and mere a contract of employment, whether expressed or implied, oral or writing, employed in the work in any capacity showed in Schedule Roman II of the Act is sufficient. The learned court further referred to Schedule Roman II and has observed that list of persons who, subject to provision of section 2 within bracket 1 within bracket N, are included in the definition of workman, and in that list it included a person employed in setting up, maintaining, repairing or taking down any telegraph or telephone line or post or any overhead electric line or cable or post or standard or fitting and fixtures for the same are also included. The learned court also considered the definition of employer under section 2 within bracket E and has recorded that when the services of an employee are temporarily lent or let on hire to another person by the person with whom the employee has entered into a contract of service or apprenticeship, means that such person, while the employee is working for him, the term managing agent as defined under section 2F has also been taken into consideration. The learned court also recorded that the opposite party number 1, that is Jharkhand State Electricity Board, and opposite party number 2, that is Subdivisional Officer Kanke Electric Subdivision under Jharkhand State Electricity, falls under Jharkhand State Electricity Board, and was of the view that if OP number 2 employs any person for managing trade and business of OP number 1, then OP number 2 shall be employer under the definition of the Act. The learned court thereafter discussed all the witnesses in paragraph number 20, which is as follows. Paragraph number 20 पूरा कोट कर दीजिएगा, ठीक है? The learned court also considered the evidence of opposite party number 1. In paragraph number 21 as follows, and ultimately recorded its findings on appraisal and scrutiny of the evidences in paragraph number 22 as follows. Para 22. This court finds that पूरा नहीं ज़रूरत पड़ेगा, लेकिन आप एक बार डाल दीजिएगा, ठीक है? This court finds that the learned court has meticulously examined the evidences placed before the court and has clearly recorded a finding with respect to CW1 that this, from the perusal of evidence of this witness, it is established that junior engineer and assistant engineers of Electricity Board Kake were employing private electricians for the trade and business of the board. This court also finds that there is consistent evidence on record that the deceased was employed, the deceased was doing the repair work under the direction of the assistant engineer Shri Ramnath Ram. And during the course of such work, he received injuries by electrocution and died on the spot. This court also finds that there is consistent view that there is consistent evidence that after the incident, some money was also given to the wife of the deceased for the purposes of cremation of the deceased. This court finds that there is uncontroverted evidence on record that the Electricity Board used to employ private electricians also for the trade and business of the board, and the manner of the incident and the fact that the deceased was working under the instructions of the officer of the Electricity Board has also been duly proved before the learned court. The conduct of the Electricity Board in providing some financial help to the wife of the deceased has also been duly established. There is consistent evidence that the deceased used to work for the electricity department under the instructions of for the purposes of repair of the electricity line. This court finds that the findings of the learned court in paragraph 23 is based on due appreciation of materials on record. Paragraph 23 is quoted as under. In view of the evidences discussed in the impugned order, this court is of the considered view that there is sufficient evidence on record to establish the relationship of employer and employee for the purposes of Employees Compensation Act 1923. The impugned order cannot be said to have been passed on no evidence. There is no scope for further reappreciation of evidence once the findings has been recorded on the basis of materials placed on record. Accordingly, this court finds that the impugned order is well discussed and in absence of any perversity or any glaring illegality, the impugned order does not call for any interference. Accordingly, this petition is hereby dismissed. There will be some improvements in the dictation, but this is by and large the.
I didn't get it.
There will be some corrections, and I will deal with this judgment also of Andhra Pradesh High Court. I will just put the relevant paragraph. It is required to be stated because these are all online recorded proceedings.
Yes.
So there will be some corrections, but this is the operative portion of the order. एक और जजमेंट है सुप्रीम कोर्ट का, आई विल साइट.
Yes.
Yes. ये
Item 4, WPS 5316 of 2023.
Lord, in this case, Lord, the case of the petitioner is that Lord, this petitioner, my Lord, had participated, my Lord, in the selection process for the post of, my Lord, constable within bracket, my Lord, general duty in the examination of Central Armed Police Forces, my Lord, and the examination is of the year 2022. Lord, it is the admitted case, my Lord, counter has been filed. It is the admitted case that, my Lord, I have succeeded in the written examination, Lord, physical efficiency test, Lord, detailed medical examinations, and even my verification of the document has been taken place, Lord, I have been found to be fit. Now, the only problem is regarding, my Lord, want of biometric data. This is what, my Lord, they have said in the counter affidavit. My Lord, kindly see for a moment the counter affidavit.
there was a mismatch.
There was a mismatch. Now, my Lord, when there is a mismatch, my Lord, this problem has cropped up, and my Lord, the Kerala High Court as well as the Jammu and Kashmir High Court, my Lord, has dealt with this kind of problem, and I am relying upon, my Lord, those decisions.
They are still in the process of
Lord, they
verification.
have said that they are in the process of publication of result. But my Lord, my case is, my Lord, based on that decision and this decision also. My Lord, this decision has been followed in that decision. When there is some, my Lord, want of biometric data verification relating to biometric data, my Lord, then appointment letter is to be issued. So this is what, my Lord, the Honorable Court says. And my Lord, I will be ready to file my notarized affidavits. This is what, my Lord,
As
the-
long as you see, it's a case where your biometrics data is mismatching. We can't take that risk in armed forces.
But then at least, my Lord, the particular time frame be made within which.
By default, you see, you cannot get the appointment by default. That if the time frame is over, then you will get the appointment.
Lord, this is a procedural event.
It is not procedural.
Lord, what
Your
happened?
identity is under cloud. It is not a procedural thing.
Lord, what happened, my Lord? Biometric data was not taken, my Lord. I have given all my thumb impression on a sheet of document. This is what my client has instructed me. Only at one point of time. For twice, my Lord, we have given biometric data and all. So, Lord, it's a procedural. If, my Lord, it's not a case of impersonation, my Lord. I will be filing affidavit and everything. And if I will not file, my Lord, my affidavit, then at least a time frame be made, my Lord, within which time frame, my Lord, everything has been done. Lord,
What is a mismatch? What is during the process of DV, DME?
Well, this is a detailed medical examination. During that process, well, so far as the documents which is being filed by the petitioner, well, and the biometric verification was being done during that process itself.
And Lord, para 6 says that final result of the petitioner is under process.
Yes, well, that has
How
been
much
said.
time do you expect to do the needful?
Well, in fact, it was sent in the month of November itself. Well, I'll have to take instruction on how much time they will take.
You can expedite it.
Yes, well, we can. Well, so far as that part is concerned.
And
Because we because in the
you
letter
see,
itself, it will
there
appear
can be
that
two
the-
things. You expedite it. I can give a time frame, and even by that time frame, if you are not able to do it, you just intimate him that you need further time or whatever is the final outcome.
Yes, well,
He
that
may
can-
have a cause of action
Yes,
once
well,
the
that
final
can be-
outcome is there.
That can be.
That can be
yes,
done.
yes, that-
Because identity is a very
Yes, well,
serious
a
thing.
very important thing, Manu,
It's
so
very
far as the
important.
verification that part is concerned,
Suffice.
that too in the- That is the reason, Manu, we have stated with regard to the fact, Manu, with the process which is going on.
In fact, my Lord, page number 3 of the counter affidavit.
Election 4, you will also
No,
see-
you see,
Annexure 4.
in this particular case, it was sent to the for forensic examination and the result was awaited.
But in
Right?
that case
In
also,
your
Lord,
case, there is a mismatch at the threshold.
but that's
So that has to be cleared.
Lord,
And
annexure
unless they
4,
are
Lord.
satisfied about your candidature, nothing can be done.
Lord, Lord, page number 3, my Lord, annexure 4. Lord, it is stated that as intimated by presiding officer, my Lord, sub RSC group center CRPF Ranchi White is letter number such and such, dossier of roll number such and such has been forwarded to deputy inspector for further necessary action at their end.
That's
Lord,
right.
there in
That
the
has been
process,
said
the
to
time
them.
frame, my Lord, is there.
देखिए WPS number 5316 of 2023. The learned counsel for the parties are present. This petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner had participated in the selection process and has cleared all the stages of recruitment, but the result of the petitioner has been withheld due to the technical issue for want of his biometric data verification. The learned counsel has submitted that the petitioner is ready to do the needful, including giving his photograph, thumb impression, and Aadhaar number, etc. And in the event any impersonation is found, his candidature may be rejected. He has submitted that the appointment letter, the result be declared and appointment letter be issued subject to ultimate verification by the respondents. The learned counsel appearing on has also relied upon a judgment passed by Honorable Kerala High Court in dated 6th of October 2021, passed in WPC number 12732 of 2021, and I submitted that in that case also there was technical issue and appropriate order has been passed.
And my lord, in Jammu and Kashmir.
Passed and a direction has been issued that the candidates would be appointed provisionally subject to FSL report.
And my lord, in Jammu and Kashmir High Court, my lord, the matter was not sent for FSL.
The learned counsel appearing on behalf of the respondents has opposed the prayer and has submitted that as per counter affidavit paragraph 5, the biometric verification of the petitioner was mismatching in the process of detailed medical examination. And therefore, the final result of the petitioner has been withheld by treating it as a suspected case. The learned counsel submits that unless the verification of the petitioner is satisfactory to the respondents, a verification and identity of the petitioner is satisfactory to the respondents, no appointment letter, no direction be issued for issuance of appointment letter. As per the counter affidavit, the respondents are in the process of completing the process of verification of the petitioner. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds from the counter affidavit that the respondents are in the process of verification of the identity and candidature of the petitioner. And as per paragraph 5 of the counter affidavit, during detailed medical examination, there was mismatch with regard to biometric verification. On account of the stand taken by the respondents in paragraph 5 of the counter affidavit, this court is not inclined to issue any direction to the respondents for declaration of the result of the petitioner unless the verification is done as per up to the satisfaction of the respondents. However, the fact remains that the process of verification cannot be deferred for cannot remain pending for an indefinite period of time, and accordingly the respondent number who will do the needful.
The matter has been sent to Durgapur DIG. Next 4 years also can be sent.
Accordingly, the respondents and the authorities under the respondents are directed to expedite the matter regarding verification of the verification/identification of the petitioner, and the needful be done as expeditiously as possible, but not later than a period of 4 months from today. So far as the judgment passed by Kerala High Court is concerned, this court finds that in the said case, the matter was forwarded for forensic examination and the forensic report was awaited, and there was only a direction to issue provisional appointment. But here, at the threshold, there is an adverse report at the time of detailed medical examination regarding mismatch, and therefore this court is not inclined to pass similar order that has been passed by Honorable Kerala High Court.
Item 5, WPS 7145 of 2023.
The transfer order is under challenge mainly on the ground that it has been passed by the incompetent authority. Can you come to page number 41?
Why have you not filed your count? Have you joined?
No, my lord, I have not joined, my
Why
lord.
have you not joined?
But since, my lord, due to some medical reason, I have not joined, my lord. And I have filed an IA for stay also, my lord. IA number 278.
Medical reason is not the ground for challenge to transfer order.
No, not challenge to transfer order.
No, you joined. That is the law. You can't.
But it has been passed by incompetent authority. He has got no jurisdiction. Can
That will be decided and you will be reverted back to
if
wherever you
lordship
are.
can look only one.
I will simply observe that there is no stay order and you have not yet joined. Please, why don't you file your counter affidavit?
Lordship, we have received SOF yesterday itself.
And what is your stand?
Lordship, I have not produced the same. Lordship, I am only praying for 3 weeks time.
3 weeks time.
Where will you file the counter?
When you have received the SOF, why do you need 3 weeks time to file the counter affidavit? Your officer is not available in Jharkhand.
Lordship,
He has gone for medical leave.
2 weeks.
Why 2 weeks? You have already received. Who has given you the SOF?
Lordship,
If you want 3 weeks time, I will stay the order of transfer.
2 weeks.
Who has given you the SOF? Who has to swear the affidavit?
Lordship,
Who has to file the affidavit?
Lordship, I have received the SOF.
You have not even opened the file.
Lordship, I have.
You have not opened the file. You are just simply wasting your time.
Lordship, the civil surgeon is wrong.
The matter relates to policy as to who can pass the order of transfer. How will civil surgeon file an affidavit?
The secretary.
Yes. You have not seen that order. भाई वो डिवीजन बेंच वाला ऑर्डर सबको दिखा दीजिए. Nobody less than the secretary can file an affidavit before this court, particularly when the matter relates to policy. The learned counsel for the petitioner is present, parties are present. The learned counsel for the respondents has submitted that she has received instructions from respondent number 5 to file an affidavit. However, the specific case of the petitioner is that the transfer order is in contravention of clause 9
Clause 9.
of the policy of the
Service.
state.
Some service.
Of the service rules. This court is of the view that under such circumstances, the counter affidavit should be filed by respondent number 2. At this counsel for the petitioner prays for time, let the counter affidavit in the matter be filed by respondent number 2. By 2nd of April, post this case on 3rd of April. However, it is made clear that this court is not inclined to stay the order of transfer. Certainly, if the petitioner has joined the post or it will be observed.
Since
It is made clear that
Supreme Court has
No,
also
no.
have clearly stated there are several judgments, my lord, that transfer order can be passed only by the competent authority.
That's it. However, it is made clear that this court is not inclined to stay the order of transfer.
I may be disposed of.
Where is your IA? IA is not on board.
2781 of 2024.
RG file you है ना? However, it is made clear that there is no stay of the impugned order of transfer. At this counsel for the petitioner has submits that today itself he has filed an application for stay.
Since they have not filed the counter affidavit, only on that ground.
That's it.
That is
Since
main
the
point.
respondents have not filed
For
the
2
counter
months,
affidavit,
madam.
however, this court is not inclined to stay the order of transfer. The joining of the petitioner will be subject to the result of this case. IA number कौन सा number है?
2781 of 2024.
2781 of 2024.
Is dismissed. I'll cite a judgment that you are supposed to join and then
It's
you
also-
cannot, that filing of the writ petition by itself is not a,
If Roship can place my judgments also, my lord. There are 2 judgments of the Honorable Supreme Court where the court has specifically stated that the competent authority is only empowered to.
certainly that will be decided ultimately.
My lord, that I have
We will see
taken this
that.
up for 2 months, my lord. They have
Where
not
is your letter of appointment?
Annexer 1, my lord.
Who has appointed you?
And director health service, my lord. He is the competent as per the service rule, my lord.
You join, we'll see, we'll
He is the
decide.
service.
We will decide the case.
From Delhi
And
list,
madam, if the counter affidavit is not filed, a very serious view is going to be taken. Let a copy of this order be communicated to respondent number 1 to ensure compliance. Then we'll book him.
from Delhi list for final disclosure item 1, WPS 444 of 2023.
We are not going to adjourn from this one.
No, only original records were called.
Need not, yes, but if you don't produce, that's your problem.
Which is the difficulty is the officer who.
You don't.
who was the
No
responsible
difficulty.
on
You have not
the-
filed any IA also. You have not intimated the court also. Why should I waste my 15 minutes reading your brief? If you want adjournment, I'll give you, but you have to pay cost for it. No, we don't encourage this kind of practice. I just don't like it.
Because for swearing the affidavit also somebody was required to be present.
We
here.
don't know.
He was on.
No advance notice of adjournment has been served. I only know this. Were you intimated about it? No intimation to the petitioner. No intimation to the court. You take the court for a right.
No, no, no. Today. he
This
has
no,
joined-
you just
I had
tell
asked
us.
him-
This annexure 3,
Yes.
Form B is not in dispute. You have not disputed that Form B is not there or this is a forged document. That is sufficient. He has annexed Form B.
But subsequently, after we have also brought on record that he has himself filled up Form PS3, wherein he has disclosed
Where is PS3?
PS3 in the counter affidavit, Your Lordship.
Yes.
Annexure. Lordship will say it on the basis of Form B. There is no issue.
That's it.
Because we also take, yes. No, only because the default is on my part, I taken it.
Not required. Not required. You
That-
just
yes.
on that day I did not see that Form B is on
Lordship will
record.
do it on the basis of Form B.
On the basis of Form B, then the consequence has to follow.
Yes.
Then his date of retirement would be taken as
November 23. 30th of November.
30/11/23.
No, whatever is the consequences, Lordship, because Form D, as a counsel, I may say my submission
Yes.
may not be recorded, that in cases where the petitioners dispute, we say that the Form B is pending on them.
That's
It is statutory.
right. So what consequential relief do you want? Your date of retirement will be treated as
30th of November.
30/11/23.
Paid my salary for the intervening period. And all.
Entire salary. They have not done any work.
My submission will be entire salary that it's your lawsuits.
I shall just you have filed it on 28/1/23,
Yes.
right?
So the first my order was to place it for orders, but I didn't really disclose.
Just a moment. The first day for filing the counter affidavit is 21/2/23, and then they have been taking time. Anyways, Nikhil. Learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that as per the records of the respondent, the statutory register Form B being maintained by the respondents under the mines rules. The date of birth of the petitioner has been recorded as
2nd of November 85.
2/11/1985, and therefore the petitioner was due to retire on 30/11/2023. The learned counsel has further submitted that the respondent's white letter dated 19/1/23. Sorry, which was the letter?
That is annexure 10, page 25. 23rd of August 22, we have informed that he will be retiring.
Annexure 10.
Yes, type copy.
But this is Coal India Limited. That is not.
Annexure 4.
White letter dated 16/12/2022 informed the petitioner that the petitioner would retire on 31/1/2023. He submits that the petitioner represented against the same, and when no action was taken, the petitioner has filed the present writ petition. The learned counsel has submitted that it is the respondents who are disputing the date of birth of the petitioner at the fag end of his service, and on the basis of Form B register, there can be no dispute in connection with the date of birth of the petitioner. The learned counsel appearing on behalf of the respondents may it is on. The learned counsel has also submitted that as per the circular issued by Coal India Limited, as contained in Annexure 10 dated 22, date क्या है इसका?
23rd of August 22.
23rd August 2022, it has been decided that the retirement notices should be issued 1 year prior to the scheduled date of retirement, and in the present case, the retirement notice has been issued on 16/12/2022, giving the date of retirement as 31/1/2023, and therefore the action of the respondents is in violation of the circular issued by Coal India Limited. The learned counsel appearing on the counsel has also submitted that had the notice been issued at relevant point of time, the petitioner would have approached this court and would have continued in service till his actual date of retirement. But as the circular of Coal India Limited was not followed, the petitioner filed the writ petition prior to retirement, but during the pendency of this case, the petitioner has attained the age of superannuation even if the date of birth declared by the petitioner is taken as correct. The learned counsel appearing on behalf of the respondents has submitted that the counter affidavit indicates that the petitioner had submitted the nomination, submitted the form PS3 form giving particulars of his family members and PS4 forms giving the nomination form, and in the said form there has been cutting. The learned counsel has submitted that the when was it given? Any date?
Yes, 3
28/3/2000. Not you will find it at page 14 in the bottom.
28/3/2022.
No, 28 2000.
2000.
Okay. He submits that this the aforesaid form was filled in the year 2000, and therefore the date of birth of the petitioner has been rightly taken, and the petitioner has been rightly issued the superannuation notice.
But let me also put in my note that I could not dispute that form B is a statutory register.
The learned counsel, during the course of hearing, the form be annexed along with the writ petition declaring the date, taking the date of birth of the petitioner as 2/11/85 is not in
No,
dispute.
no, 2/11/85, 22 years as on 2/11/85.
Or 22 years as
As
on
on
2/11/85. Sorry.
Initially also there was
Ah.
this.
Initial may be 22 years as on 2/11/85 is not in
That was
dispute.
my mistake.
After hearing the learned counsel for the parties and considering the facts and circumstances of this case, it appears that the recording of the age of the petitioner as 22 years as on 2/11/1985 in Form B statutory register under Mines rules is not in dispute. It, however, appears that the petitioner was served with notice of superannuation on 16/12/2022, showing his date of superannuation on 31/1/2023. Apparently, the superannuation notice was issued at the fag end of his service career, and 1 year advance notice in terms of Annexure 10 has not been issued to the petitioner. The petitioner had represented against the said superannuation notice, but no decision was taken by the respondents. And just a few days prior to his age of superannuation, the petitioner filed the writ petition on 28/1/2023. And in the meantime, the petitioner attained the age of, the petitioner was made to retire on 31/1/2023. This court finds that the issuance of superannuation notice just a little more than 1 month from 31/1/2023 is in violation of the circular of Coal India Limited as contained in Annexure 10. This court also finds that the Form B register, which is a statutory register, and the entries made therein is not in dispute. However, the respondents have tried to justify their action by referring to PS3 and PS4, which is a declaration regarding particulars of family and the nomination form. This court is of the considered view that the Form B register, which has been filled up at the time of entry of the petitioner in service, was never corrected, and the entry made therein cannot be disputed by the respondents. It appears from the records of this case that the respondents have, it is the respondents who have tried to disturb the date of superannuation of the petitioner by issuing the notice dated 16/12/2022, although as per the statutory records of the respondents, the age or the date of superannuation of the petitioner would have been
30th of November 23.
30/11/2023. In such circumstances, the impugned action of the petitioner in retiring the petitioner on 31/1/2023 cannot be sustained in the eyes of law. Consequently, the petitioner is, and the date of retirement of the petitioner has to be taken as 30/11/2023 with all consequential benefit, and so far as the wages are concerned, the petitioner would be entitled only to the extent of 50%.
In one case, the lordship has increased the last 75%. Lordship seems-
75%?
This order. I was doing that case also, 75%.
कुछ तो होगा उसमें.
नहीं उसमें in fact the court was inclined to give 100%, but earlier the court had asked me to give an affidavit as to on what I would be agreeable. I said 75. Your lordship has underlined it.
No, that much is 50% is
75%.
The state petition is accordingly disposed of. That superannuation notice has to be set aside.
Yes,
Has to be crossed.
Okay. The impugned order is set aside.
Manoj, your lordship may say,
The-
retirement benefit will be calculated on the basis of.
I have already said all consequential benefits. Everything you will get. The 50% back wages we paid to the petitioner within a period of 2 months from the date of representation, failing which the same would carry an interest of 12% per annum till the date of payment.
Item 2, WPS 1361 of 2023.
You have got it?
Yes,
May not be required.
it will be required.
What do you want to show to me?
2-3 things. Here there is no form B. Lordship, what has happened in this case, at the time, if your lordship sees from the bottom,
That form B is not there.
he was never employed in a mine, he was in the hospital.
That-
They filed an affidavit that there is no form B.
But
Because
you
he
have-
was not appointed in our mines.
But
The
form
mines-
B is not in dispute.
No, form B is not there. Form B cannot be, form B was not required to be opened for a person not employed in the mine.
No, but you have opened form B for
No,
him.
no. Second case.
Oh, second case. So
हाँ.
I was confused.
I beg your apology, Lordship. Second ये तो हो
Sorry,
गया.
no problem.
इसमें
Yes,
तो
yes.
record ही नहीं है.
This one, Manoj Kumar Sinha. All right. Let us see. दोनों में रिकॉर्ड के लिए बोले थे क्या? हम एकदम कंफ्यूज हो गए हमारे ये फॉर्म भी का कहानी का. Yes, tell me.
But I'll just, may I tell the facts? Maybe
Yes.
yes. Lordship, when he was appointed, if Lordship sees the original records, from the bottom it starts. Lordship, we kindly come to page 8 first from the
My
bottom.
lady, I do not have copy of those. I just wanted to indicate that.
Let him just say, and you can have a look at
I'll
it.
have a fair, I'll be fair to him also and everybody.
You can just have a look at it. Let me
I have
let
got
me
the
just hear
one
him.
copy I have got.
Yes, tell us.
Page 8, if your Lordship says.
Page 8.
Yes. Lordship, before appointment, he was subjected to medical test. Lordship, it has been flagged, age assessment.
Age assessment. Yes.
Lordship, at the time of appointment, he also disclosed as per his statement it was 24 years, and as per his appearance also it was 24 years.
Okay.
Now, your Lordship, kindly come to the appointment letter. Lordship, that is also flagged here, Lordship. You can see the flags.
Appointment letter. Yes, with reference permission for higher studies.
No, that is for matriculation.
Board examination. He was
was
appointment
non-med-
letter. You have
yes.
marked it as appointment letter. Yes, yes, yes. Yes, appointment letter.
Lordship, appointment
Age is
letter
mentioned.
also- Age is mentioned.
Okay.
24 years.
Okay.
As on 24 years, as on 13/3/1987.
That's right.
Now, Lordship, when his service excerpts were opened, Lordship, can you see the first page, the last page of the file?
Yes, last page.
Yes, because it was in a torn condition.
Hmm.
There, your Lordships, his age has been mentioned, date of birth has been mentioned as 21/12/63.
Last page of the file.
Lordship, it will be in this format,
Okay,
in carbon copy.
This one.
Yes, it was in a bad condition.
Okay.
At the end, your Lordships, 2 pages
Service, this is Shiksha board.
But it will be in a thin paper, 2 pages.
This one.
Maybe that document, yes.
21,387.
87.
Yes, where is it mentioned?
Last
Last
in the
page.
first page, your lordships.
First page I have seen.
Yes.
24
Age-
years.
No,
This is appointment letter.
Appointment letter.
अच्छा उसके अलावा कुछ.
Service accepts.
This is service acceptance.
Yes.
Okay, fine.
Serial number 6. Date
Yes.
of birth 21/12/63. It has been mentioned.
It should have been.
Lordship, it should have been 24 years as on 24 years as on 13/3/87.
So this is incorrect.
This is incorrect. And Lordship, thereafter in 1990, he sought an permission that I will do my matriculation. We gave him permission. In the matriculation, he disclosed this date of birth. Other than that, there is nothing. So our case is Lordship, the first in the appointment letter he never disputed. After receiving the appointment, he joined. So Lordship, any erroneous entry in the service excerpts, Lordship, that will not prevail over the initial appointment letter. At the time of joining also, during medical test, he disclosed his age as 24 years. We took
You
it.
see, service excerpts. This recording is on the basis of 10th pass. Because in service excerpts, he discloses his educational qualification as 10th pass,
10th is
which he had undertaken during the course of
during.
employment.
Therefore, we have flagged here also the permission letters, permission which he has sought and permission which was granted.
Yes, what do you say?
And the first thing is, ma'am, their appointment letter that is being shown, that is offer for appointment, in that it has been said in the second page
Yes.
that you should bring following documents in original with one attested copy of each.
At the time of, just a moment, let me take down the dates. What is your date of appointment?
I have provided one synopsis also.
देखिए तो कोई synopsis है इनका.
Last document.
It's not there. Did you under I have maybe under I was- No, you just give me the foundational date.
I first show the,
If you have a copy of synopsis, you can give.
yes, I have edited copy.
Is-
Before coming to the dates already, what is action number 2 manually?
No, I just give me the date lines. Your date of appointment.
Dates I have given, the date of birth which I claimed in the table manually,
Yes.
21/12/1963. This is the date that I claimed. Thereafter on 21/3/1987 is the date of appointment.
21/3/1987, date of appointment.
Yes.
Okay.
Then this was the date on which offer of appointment was made to me. I gave my joining the second page on the same date.
Any objection to this appointment letter? From your
This-
end?
I say that this is offer of appointment and it has written in the offer of appointment that you come up with all the proofs, produce it, and your joining will be accepted. So I say that this cannot be a proof of date of birth because this is only offer that is being made.
So what all documents did you prove?
Then my lord,
Did you file for your in support of your date of birth at the time of appointment
that my lady will kindly have.
and prior to joining?
My lady will kindly have page 28, that is school leaving certificate. Page 28.
'28. Yes. What did you file?
This is the document in this Vidyalaya because at that point of time I was not matriculated. So school leaving certificate of Madhyama I produced, and in this the date of birth has been recorded as to be 21/12/1963.
Okay.
Then my lady will kindly have in the synopsis. I continued on the post and in all the records like identification certificate, my I-card, my CNPF record, service book, everywhere 21/12/1963 was recorded. And I have also annexed one circular which says that if there is dispute, the service record will be looked into. Thereafter, on 21/12/2022, serial number 6, malady in the 21/12/2022, they served me a notice saying that I will be retiring on 31/12/2023. That is 1 year prior to my retirement. This is the claim date of birth. According to the claim date of birth, that 21/12/2022, it says
How much is the difference?
9 months.
Okay.
Thereafter, so 6 I do not dispute. 6 notice at serial number 6. That is the connection number 2. All of a sudden, at serial number 7, my lady will have. This is the impugned notice. On 28/2/2023, they say that I'll retire on 31st of March 2023. 3 days thereafter. So, in the entire service record, they do not raise this dispute. 3 days prior to this, they say that I'll retire on 31st of March 2023. And there are few judgments if my lady will allow. There's one judgment of Honorable Supreme Court.
This document of Madhyama is very much in your record.
No, that is there. We gave him a permission for that.
No. This document of Madhyama,
Madhyama, yes, from Sanskrit board.
no,
For that
whatever
only-
it is,
Yes,
but-
for that only we gave them a permission to apply.
Permission
That is
matriculation-
subsequently.
matriculation.
no.
So that is from
The school leaving certificate?
That was page 28 is of 1983.
School leaving certificate is also there on record.
Yes, this is Lakshmi is in the copy of the writ application.
That
No.
was both
It is a copy of the
No,
writ.
this is not a copy of it.
both the documents are on record.
School leaving certificate.
One is school
I'll just
leaving
explain
certificate.
it. It has been flagged here, Lakshmi. sir.
Yes, yes. You just check.
Yes.
School leaving certificate is very much on record.
That judgment in the meantime, I will see.
This one.
Yes. In this, the dispute was in relation to determination of age. At para 29, where you will see last page of the judgment. Relying on this, the coordinate benches have also passed order.
That school leaving certificate is available on your in your record. It goes to show that he had produced it before you.
No, I'll just explain it. These documents were given subsequently. All these three bunches. One is issued in 1993, and
School leaving
therefore
certificate.
all the three has been therefore tagged together. At the
No,
end,
I
it
do
was-
not know. He must have given you.
Lakshmi can
When was it given to you? It is a part of your record only.
Yes, yes. Whatever is there as file as it is, we have produced.
Yes.
Lakshmi kindly see. It is along with
Where is your appointment letter annexed with the writ petition?
Annexure number 1.
Annexure 1. Where do you say that you were supposed to produce the documents in support of your date of birth? Birth certificate to prove date of birth, if any.
Page 20.
Matriculation certificate and other certificates to prove the educational qualification.
Second page of that document. And in the opening itself, it says this is the offer of appointment, subject to verification of my lady will have page 21. And it is that you are being offered appointment as so and so. Thereafter, in the next page at serial number 9, you should bring the following documents in original with one attested copy at the time of joining. So this is the only problem that they raise in the impugned notice. My lady will kindly have the impugned notice. Page 24. First, my lady will have kindly page 23.
Page 24.
Yes. Before that, page 23, my lady will have.
Yes.
And this is in my favor. Company, this has been issued by the company itself. कंपनी के अभिलेखों से आप में आपके जन्म तिथि 21/12/1963 अंकित है। तदनुसार दिनांक 21/12/1923 को 60 वर्ष की आयु पूरी कर कंपनी के प्रावधानानुसार आप दिनांक 31/12/2023 के अपराह्न से सेवानिवृत्त होंगे। Now this is the notice 1 year prior to the date of proposed retirement. Thereafter, at page 24, they go beyond that melody and say पत्रांक इतना इतना 21/12/2022 के तहत आपको सेवानिवृत्ति की सूचना निर्गत की गई थी, जिसमें आपकी जन्म तिथि 21/12/1963 दर्शाई गई थी, परंतु आपके सेवा संचिका में संलग्न नियुक्ति पत्र एवं इनिशियल मेडिकल बोर्ड के कागजात के अनुसार आपकी उम्र दिनांक 13/3/1987 and their own circular my name will kindly done in my rejoinder I annexed. At annexure 7 page 10, rejoinder affidavit dated 5th of April 2023.
Page 10.
Page 10. In this, the heading goes on to say determination of age at the time of appointment. Thereafter, relevant is at para C, capital C. Next page. Age determination committee of the medical board for the above will be constituted by the management in the case of employee whose date of birth cannot be determined in accordance with the procedure mentioned in so and so, the date of birth recorded in the records of the company, namely Form B register, CMPF records, identity card will be treated as final, provided that where there is a variation in the age recorded in records mentioned above, the matters will be referred to the age determination committee medical. Now, my lady will kindly have page number 19, that is my identity card. Sorry, page number annexure 9, page 15. Page 15. This is my I card. In this, date of birth has been recorded as to be 21/1963. Thereafter, next page is CMPF record.
I just fail to understand one thing. This is a practice of our High Court that all the relevant documents are filed only in the rejoinder.
That is incorrect.
I'm absolutely clueless.
I understand. That is incorrect.
They don't have a chance to respond to your stand taken in the rejoinder. You can't take a new. These documents are very much available with you. Why don't you file it at the time of filing of the writ petition itself?
Then after page 16, that is CMPF record.
In all the relevant records, it is that, except the appointment letter.
Offer of record.
Yes, what do you say?
That you also wanted to see. Also, you can come from the bottom page 9. So that
No,
was
I
the
just want to know that this particular document is very much in your record.
Also, it was by way of along with the representation. Page 9 is the representation. From the bottom, if you lordship says, it is a. He requested for promotion and he has enclosed all the.
You granted him promotion also?
No, promotion no.
That's right, but this document was very much there in 2017 also.
Yes, 2017 it was there. Not at the time of appointment. Now lordship will take into consideration. Page 17, which my learned friend was showing. In the rejoinder.
Just when did you pass your matriculation?
1992.
It was given permission in 1990.
by his appearance, he seems to be 24 years.
Before that line also. He has also declared his age as 24 years.
Then why did you issue him I-card for a
Also,
different date
everything
of birth?
happened after that the age was recorded.
So
Therefore, I
this
present
age
the-
which was recorded
Yes.
in this particular document,
Yes,
service excerpts,
Yes.
is
That
has
was-
not been disputed by you at throughout his service career.
Throughout, nobody lordship noticed that in the appointment letter itself the age was given, which is differing.
So it
63.
was very much within your knowledge.
No, it was within our knowledge, but lordship will take into consideration the initial date of birth which was recorded.
That's
In this
so,
case, lordship.
so you are trying to dispute the date of birth at the fag end of his career.
No, no.
So
Lordship, we said that we want to go by the first date of birth recorded,
you
not
yourself had
disputed.
issued the letter of the superannuation, isn't it?
We ourselves issued. Thereafter, the competent authority noticed that in his appointment letter, then he called for the records and he verified, and he found that even in the at the time of joining, age assessment was there. There also he disclosed his age as 24 years. Although he is bound by his own declaration and the offer of appointment which he has accepted. It becomes conclusive. If he had any objection, he would have given. But he says it is an offer of appointment. But the offer, if accepted, becomes conclusive. That is our case.
Where is his joining letter?
No,
Must
he
have
gave
given-
his joining by signing acknowledging the appointment letter. That is his statement, and that he has stated also on the same day.
Service record must be there in the service.
There is no separate.
There has to be a letter of joining.
Service record, there's everything.
Whatever is there, your lordship is there. And he has also stated that I have signed it and I have joined. And that is at page, which must be there in the original also.
Yes, moreover, they are raising this dispute on 28-2 and asking me to get retired on 31-3. 3 days Meridian. I could not have got chance to learn.
That is all.
Yes, these are the facts.
WP, you just two dates you say that you would have retired on which date
31st,
according to you?
31st December 2023.
31/12/2023. When did they make
31-3-2023.
31/3/2023? Heard the learned counsel for the parties. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner was issued a date of a notice of superannuation on 21/12/2022, indicating that the petitioner would retire on 31/12/2023, and subsequently another letter dated 28/2/2023 was issued, indicating that the petitioner would retire on 31/3/2023, and the earlier letter dated 21/12/2022 was sought to be rectified. The learned counsel has further submitted that while issuing letter dated 28/2/2023, it has been mentioned that at the time of initial appointment and initial medical board, the age of the petitioner on 13/3/1987 has been shown to be 24 years. कितना फर्क होगा? 24 years तो वैसे भी होगा.
20.
24 years has a span of 1 year.
Normally people say
24 years has a span of 1 year.
Normally people say the completed years in bachelor. They do not say the 24th year is running. He will not say 23 years. He will say 23 years.
The Learned Council has submitted that the service excerpts of the petitioner discloses the date of birth as 21/12/1963, and such date of birth is backed by the school leaving certificate as contained in Annexure 5/1, which indicates that the date of the birth of the petitioner is 21/12/1963. The Learned Council has also submitted that while in service, the petitioner passed class 10th examination in the year 1992, and his date of birth has been recorded as 21/12/1963. ये स्कूल लिविंग सर्टिफिकेट का डेट कब का है? 1/4/93.
Just provide, just we proceed as
The Learned Council has further submitted that the entire records of the petitioner reveal that the date of birth in all the records of the respondents has been mentioned as 21/12/1963. And therefore, it is the respondents who are disputing the date of birth at the fact end who initially issued the correct notice for superannuation on 21/12/2022 and tried to dispute the same by another letter dated 28/2/2023, which is impugned in the present case. The Learned Council submits that the present writ petition was filed on 14/3/2023 when the petitioner, when objection raised by the petitioner by letter dated 9/3/2023 was not responded. The Learned Council, appearing on behalf of the petitioner, has also submitted that in the letter dated 21/3/1987, the same was only an offer of appointment, and the petitioner was to submit various documents in support of his educational qualification / birth certificate, etc., to prove the date of birth. And ultimately, the petitioner joined, and his service excerpts were prepared, and date of birth has been rightly recorded as 21/12/1963. The Learned Council, appearing on behalf of the respondents on the other hand, has submitted that at the time of appointment, the petitioner was physically examined, and as per self-declaration of the petitioner, his age was 24 years, and on appearance also, he was 24 years of age. And consequently, the letter of appointment was issued on 21/3/1987. He has also submitted that the records indicate that while in service, the petitioner had applied for, had taken permission for appearing in class 10th examination, and he was granted such permission. And in the declaration in class 10th examination, the petitioner had mentioned the date of birth as 21/12/1963, and therefore in the service excerpts it was his date of birth was recorded as 21/12/1963, and which was followed in subsequent documents also. But the age as recorded on 21/3/1987 at the time of appointment has to be taken as correct for all purposes.
That
And
was never Lordship objected with.
that was never objected to by the petitioner, and therefore the impugned letter dated 28/2/2023 rectifying his date of superannuation as 31/3/2023 does not call for any interference. वो आपको बाद में issue हुआ. That school leaving certificate has been issued in 1993.
Yes. After.
Date of appointment जो है आपका 21/3/87. If we take your date of birth as 21/12/1963, तो इस डेट में आप कितने साल के हैं? 21/3/87.
Let's say
24 years.
9 months minus 9 months minus
Calculate very exact.
20.
23 years something. 23 years 1 month.
23 years,
1 month.
1 month on 21/3.
21 3 yes.
13, 21.
21/3 तो नहीं होगा.
23 years 3.
4 months. देखिए, after
4
hearing
months.
the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that on the basis of self-declaration of the petitioner and on the basis of his appearance, which appeared to the authority who had medically examined the petitioner at the time of appointment, the age of the petitioner was recorded as 24 years. And accordingly, in the letter of appointment dated 21/3/1987, the age has been recorded as 24 years. However, from the perusal of the letter of appointment, no specific date of birth has been mentioned.
24 years as on.
It has only been mentioned that it is 24 years as on
13/3/87.
13/3/87, which is the date of his appearance before the medical board
fitness.
for medical fitness. Admittedly, the age of the petitioner was recorded in the offer letter of appointment dated 21/3/87 on the basis of appearance of the petitioner and his self-declaration. No medical test with regard to the date of birth of the petitioner has been conducted. The dispute in connection with date of birth is only for a small period of 9 months. The petitioner claims his date of birth as 21/12/1963, and therefore he claims that he is scheduled to retire on 31/12/2023, and as per the respondents, the petitioner would retire on 31/3/2023 by taking his age as 24 years as on 21/3/1987. This court also finds that the petitioner acquired the passed class 10th examination while he was in service, and his school leaving certificate, though issued on 1/4/1993 and his matriculation certificate indicated that his date of birth was 21/12/1963. The said entry was admittedly made in the service excerpts of the petitioner as back as on
The date is of 1987 only,
January 19
but it could not have been on that.
as on 10/4/1987.
Yes, matriculation was belated, so it is a subsequent entry. That's
All
what
right.
I wanted to know.
All right. In the service excerpts, and it was recorded as 21/12/1963. The records also reveal that subsequently all the documents of the petitioner and all the declarations made by the petitioner indicated that his date of birth is 21/12/1963. Considering the fact that exact date of birth has not been recorded in his letter of appointment dated 21/3/1987, and there is only a minor difference between and this court also finds that on 21/3/1987 the petitioner was almost of the age of 24 years, but his exact date of birth stood recorded only in the service excerpts dated 21/12/1990, service excerpts which gave the exact date of birth of the petitioner as 21/12/1993.
1963.
So 1963. The recording of the date of birth as 21/12/1963 and in the service excerpts and all the connected records was certainly within the knowledge of the respondents, who on the basis of such document had also issued the letter dated 21/12/2022 indicating that the petitioner would retire from service on 31/12/2023, and subsequently on the basis of his initial letter of appointment in which no specific date of birth was mentioned, a subsequent letter dated 28/2/2023 has been issued taking his indicating his date of retirement as 31/3/2023. This court is of the considered view that it is the respondents who are trying to dispute the date of birth of the petitioner at the fag end of his service. Once the specific date of birth has been recorded in service excerpts and no specific date of birth has been recorded in his letter of appointment, and the discrepancy and the difference is only minor in nature, the respondents were not justified in issuing another letter of notice of retirement on 28/2/2023, although they had issued the letter of retirement on 21/12/2023, recording the date of birth of the petitioner as 21/12/1963. In such circumstances, this court is of the view that the order dated 28/2/2023, taking the date of birth of the petitioner as 31/3/2023 cannot be sustained in the eyes of law. The petitioner is accordingly accordingly the letter dated 21/12/2022 would revive, and the date of birth of the petitioner is now required to be taken as date of retirement of the petitioner is required to be taken as 31/12/2023 with all consequential benefits. Since the petitioner has already attained the age of superannuation, and in the intervening period the petitioner has not worked, and the petitioner would be entitled for back wages of the differential wages, 50% differential wages, and with same direction.
only one thing what you may record in the beginning, that in compliance of the direction I have produced the original
Okay.
and it is being written.
Okay.
So that
In compliance of the last order, the counsel for the respondents has produced the original record, and the present order has been passed, taking care of the materials from the original records, which has been placed before this court.
original file has been written.
Original file is returned back to the learned counsel for the
So that will
respondents.
complete the movement register.
That's right. There's hardly any discrepancy.
No, but look at that. But
That's
there is
right.
he has taken advantage of the subsequent change and therefore he appeared in the matriculation. That is also from Bihar.
Exact date भी नहीं है.
नहीं 24 years आज वही होता था मैक्सिमम का क्योंकि जो नॉन मैट्रिकुलेट है और इनका था कि बिहार संस्कृत बोर्ड दैट इज नॉट अ बिग इशू दैट इज आल्सो नॉट अ रिकॉग्नाइज्ड बोर्ड
छोटा सा चीज है. हाँ.
व्हिच आई टॉक टू द ऑफिसर वो बोले कि उस समय गलती से 12 हो गया इसीलिए वो मैट्रिकुलेशन में गया नहीं हो गया.
Carry on. Next.
And in the hospital as well, the doctors maintain they are not good in keeping their records in.
कुछ ये सब चीज को ना जब 24 years हो, then you should find out some rule. This will be taken as the date of birth. I think in this state government service there is a rule.
When there is a range, there is a rule for us.
In the state
As on that में actually
State में है ना 1st July बोल के कुछ.
अपलोड कर देते हैं.
अच्छा.
It is uploaded on the internet now.
ये सब तो आप लोग करिए.
Every officer.
इसमें I asked the doctor, okay, why did you not do the ossification test?
Yes.
He said that normally when I accept his statement, we do not do. We said that he also says this, I also find it.
And
But
what's
when
the validity in the
a
state?
person who says 18
all
years
the
and he
entries,
appears,
all the entries are now to be cross-checked by the. It is duty of the official.
Okay.
and nowadays we are also जो fresh appointment हो रहा है, everything is online. They
अब तो
enter
10th के
office.
पहले अपॉइंटमेंट ही नहीं होता है इसलिए बात खत्म.
हाँ. आजकल ई ऑफिस में सारा चीज आ जाता है, one click everything.
Item 3, the rupees 2829 of 2023.
Yes, petitioner. Yes, what is it?
In fact, we are just one thing you must carry see.
Yes.
We have filed a counter of development page. $15
Yes.
So that prior to 2012, there was no provision for grant of pension and family pension, etc. To the persons who are already getting pension from the other services.
Okay.
Now, after 2012, now the provision which were incorporated in the CCS pension rule that has been deleted. And after 2012, in fact, 27 December 2012, the persons who are working after the retirement from the army services and joining to the other organization, whether it is the central government or the state government, they are entitled from there also, so far as the pension is concerned. Now, therefore, the petitioner, her husband died in the year 2007, and now she can claim after 2012, so far as the family pension is concerned. But he will have to make an application to the competent authority.
Okay. Who would be the competent authority?
That is what.
You have stated so in your counter affidavit.
Yes, so far as that part is concerned, we have stated.
Who would be the competent authority?
The director CIP.
Directors. Likhit. The learned counsel for the parties are present. Kindly give your appearance. This writ petition has been filed for the following relief. The learned counsel for the respondents has submitted that the husband of the petitioner expired on 25/7/2007, and as per the counter affidavit, the in paragraph 11, it has been stated that the sub-rule 13 capital A and 13 capital B of Rule 54 of Civil Services Pension Rules 1972 was omitted by notification dated 27/12/2012, And this position was also clarified by Department of Pension and Pensioners Welfare, Ministry of Personal Public Grievance and Pension, New Delhi, by circular dated 16/1/2013, and therefore the petitioner should have applied for family pension at CIP Ranchi after issuance of Gazette notification dated 27/12/2012 and notification dated 16/1/2023, but she has not made such application. The learned counsel submits that if the petitioner applies before respondent number,
Rule 81 of the pension rule matter said,
respondent number 3.
because I am willing to replace rule 81 matter
What do you want?
for sanction of family pension matter.
Respondent number 3, appropriate order can be passed. Yes. What do you want?
But it says, if the deceased pensioner is survived by a widow or widower who is eligible for grant of family pension 1964 under Rule 54, the amount of family pension 64 is indicated in the pension payment order.
He will pass the order, whatever is your entitlement, he will pass the order. Have they denied you?
No. He is relying upon so far as the husband of the petitioner was in the army services. Thereafter, in 1986, after retirement from the army, he joined in CIP. He was getting the pension from the army also. Now, after deletion of Rule 12A and 13A and 13, sub-rule 13A and 13B of Rule 54, after 2012, they are entitled even from this service also.
Both sides.
That's
Both
right.
From both sides.
He will do it.
So that is the case also.
He will do it.
Right.
After hearing the learned counsel for the parties, this court finds that it is not in dispute that the petitioner was an ex-serviceman.
The wife of
The husband of the petitioner was an ex-serviceman, and he superannuated on
Please say, Jara,
30/11/2003
from CIP.
from
CIP.
CIP.
Central Institute of Psychiatry.
Yes. It further appears that he expired
on 25/7.
on 25/7/2007. As per the counter affidavit, at the time of his retirement, the prevailing sub-rule 13A of Rule 54 of Civil Services within bracket pension bracket close rules 1972 prohibited grant of family pension from the civil side to a
Pension.
re-employed military pensioner. Family pension from the civil side to a re-employed military pensioner if the military pensioner had opted for family pension for the military services rendered by him. Similarly, sub-rule 13 capital B of Rule 54 of those rules prohibited grant of two family pension to a person who was already in receipt of family pension or was eligible therefore under other rule of the central government or the state government. However, the said provisions have been omitted by Gazette notification dated 27/12/2012, followed by another notification dated 16/1/2013, whose details have been mentioned in the counter. And therefore, a stand has been taken by the respondents that the petitioner has to approach the respondent number 3 for redressal of her grievances. In view of the materials which has been placed on record, it appears that the grievance of the petitioner is required to be taken care of by respondent number 3, and no adverse order as such has been placed on record before this court. In such circumstances, this writ petition is disposed of, enabling the petitioner to approach respondent number 3 along with a copy of the writ records and a copy of this order. with all supporting documents. Upon filing of such representation, the respondent number 3 shall do the needful and pass an appropriate order in connection with the claim of the petitioner within a period of 4 weeks from the date of representation. The reasoned order be communicated to the petitioner through speed post at the address to be provided by the petitioner, and the admissible dues arising out of such reason, the respondent number 3 shall also take appropriate steps so that the admissible dues, if any, arising out of the reasoned order is also paid to the petitioner within a period of 2 months from the date of the reasoned order. This petition is accordingly disposed of.
Item 4, the LPS 4827 of 2023.
By the making of the last order that is 2024, Lordship had directed the housing board respondent number 4 to file counter affidavit, and yesterday they have served with a copy of the counter affidavit.
WPS number 4827 of 23, counsel for the petitioner prays for time to file rejoinder to the counsel counter affidavit filed by respondent housing board.
इधर फाइल नहीं हुआ होगा
नहीं हुआ है.
ओके इसलिए कि 48 आवर्स पहले होना चाहिए
Permission लेके
अच्छा that was not
let the rejoinder be filed by कितना आपको टाइम चाहिए?
10 days.
Let the rejoinder be filed by 21st of March 24. क्या मैटर है आपका?
Matter relates to two-fold lordship petitioner superannuated from the post of clerk on 31/5/2010 from the housing board, Jharkhand State Housing Board, and he is paying for gratuity to the extent of ₹10 lakhs. And second, as per the Annexure 12, there is an order of the housing board that so long as the service rules are not formulated for the Bihar State and Jharkhand State Housing Board.
आपका क्या stand है?
Your Lordship, everything has been paid. Your
That is their thing.
gratuity, they are demanding 10 lakh rupees. Your Lordship, it has come in force in 2011.
Just a moment. The learned counsel for the respondent housing board has submitted that all the admissible dues has already been paid to the petitioner as per the contract. Pose this case on 3rd of April under the heading for final disposal. The parties to file their synopsis list of dates by 1st of April.
In fact, Lordship, the Nagar Vikas Bureau Housing Department has issued a notice that so long as the service regulations are not formulated by the Bihar State Housing Board, the service rules of the state government will follow. So on that basis, he is claiming pension and gratuity of 10 lakh.
Pension is not being paid.
Your Lordship, there is no scheme of pension in housing board. Your Lordship,
Lordship,
there is
we
payment
have
from the
we have
EPF.
We'll see that.
Lordship,
There is
Lordship, after filing
Item
of
5,
this application,
the LPS
the
double five
respondent
30 of
provided for
2023.
concern has stopped making payment of the pension. That will be released, Lordship.
Yes, petitioner.
Item 5,
You are there in this case also.
No, last case of serial number 4, the Provident Fund Commissioner, they were paying pension to the petitioner, and now it has been stopped after filing of this writ
We
application.
can't do anything about it. It will be decided. You are only seeking time. Yes, petitioner.
In this case, we need to file a reminder number. We will not file it yet. The counter was received last week. We have not,
The learned counsel for the parties at present. The learned counsel for the petitioner prays for time till 21st.
2 weeks time.
2nd of April 22 to file a rejoinder to the counter affidavit. Post this case on 24th April under the heading for final disposal. In the meantime, parties to file list of dates. आप file कर दीजिए. List of dates, synopsis of parties.
Item 6, WPS 6675 of 2023.
State of Bihar contract file counter.
Ideal contract.
Not file, more time.
WPS number 6675 of 2023, the Learned Council for the State of Bihar prays for and is granted time till 30th April.
रिकॉर्ड बहुत पुराना है, मिल नहीं पा रहा।
30 अप्रैल।
ठीक हम
हम जान रहे हैं आपका पुराना रिकॉर्ड है। To file, to comply the order dated 19th of February 2024. Rejoinder, if any, by under the heading for admission.
Final soon चल रहा है.
अच्छा ठीक है. Final disposal under the same heading.
Item 7, WPS 6984 of 2023.
Pray for Shwan Paso.
May I submit your leadership? The main authority to decide the transfer of the petitioner is Regional Chief Conservator of Forest, but that post is currently vacant. So the respondent number 5 has sought guidelines from the respondent number 2 to issue some guidelines. So for that matter, further 2 weeks time will be granted to leadership to file the.
What is the prayer?
What's my prayer is to transfer this petitioner.
You are seeking a direction for transfer.
What has happened in this case? This petitioner was initially appointed 10
I
years
do not
back.
know what kind of direction can be passed for transfer.
But sir, there is no specific rule to that. But
Then
what
we
has
can't.
happened?
You have to show the law to get an order.
But sir, what has happened?
You see, he has just now said that some kind of representation they are taking care of. So you don't pursue. I can't issue a direction for transfer.
But only one thing yes. But there are 3 persons who have filed representation after me before the department. I have given the name of those persons.
We can't issue a direction for transfer.
But at least a direction to consider my representation.
You pursue your representation.
I have given
before whom?
Before whom? Before the respondent number 2, your leadership.
That can be taken care of by respondent number 2?
Yes.
Learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel has submitted that the petitioner has raised his grievance before the respondents, but no order has been passed. At this, the learned counsel for the respondents has submitted that the grievance of the petitioner can be considered by respondent number 2. After hearing the learned counsel for the parties and considering the nature of relief as prayed for in this writ petition, this court is not inclined to issue any direction upon the respondents to transfer the petitioner. Essentially, the transfer is a matter of policy and it is within the domain of the respondents. However, this observation will not be an impediment in the way of the petitioner to raise his grievance before respondent number 2, and as submitted by the learned counsel for the respondents, the grievance of the petitioner can be considered by respondent number 2. This writ petition is accordingly disposed of. It is expected that the respondent number 2 shall do the needful as per the. It is sufficient to observe that if any representation is filed by the petitioner, appropriate order The appropriate decision is required to be taken by respondent number 2 expeditiously.
Though my presentation is already pending, so I will state it.
Expeditiously is sufficient.
So I think if my lord kindly mentions one thing, my lord, that after my representation, 3 persons have been transferred on
I
their
will not say anything. वो आप सारा कुछ वहीं बोलो.
Item 8,
or
WPS 7588 of 2023.
May I give my copy of the writ itself in the representation?
You do whatever you have to do. Petitioner.
The affidavit has been filed yesterday by the respondents. 3 weeks time.
WPS number 7588 of 2023. Counsel for the petitioner seeks adjournment to file a rejoinder to the counter affidavit. Let the rejoinder be filed by 4th of April.
1 more week.
3 weeks आप बोले, exactly 3 weeks आपको दे दूँ.
Vacation है.
एक वेकेशन में डिलीट हो जाता
Only
है.
1 week.
It gets deleted from the calendar
Only 1 more week.
by 10th of April. Pose this case on 1st of May under appropriate heading. ये क्या final disposal नहीं है? Under same heading.
For orders, Item 9, Penal Revision 90 of 2019.
After? What is it?
This is for crossing of order.
What is the prayer? Why is it listed for orders?
The prayer is to.
Why is it listed for orders? Okay, let us see.
Item 10, Item 10, WPL 1918 of 2023.
मतलब कुछ नोटिस सर्व हुआ था, ऐसा रिपोर्ट नहीं आया.
You take fresh steps. This is BCCL. Notice was issued to whom? Respond number 3. आप personal service लेंगे. Personal service
Personal service.
लेंगे.
Direction.
WPL number 1918 of 2023. Notice was issued upon respond number 3, but neither service report nor undelivered registered cover or AD has been received. The learned counsel for the petitioner raised for is directed to take fresh steps for service of notice upon respond number 3 under speed post as well as through personal service. The requisites for the same be filed by (18th of May 24). The affidavit regarding service of notice be filed by 9th of April. Office is also directed to track the speed post delivery. Post this case on 15th April. Awaiting service report.
Item 11, WPL 3336 of 2023.
Notices were issued. It has come with a remark that he has left. At this point.
WPL number 3336 of 2023. The notice has remained unserved. The counsel for the petitioner is granted time till 3rd of April to take fresh steps for service of notice upon sole respondent at his present and correct address, or to file an appropriate petition regarding substituted service of notice. Post this case on 11th March. On 8th of April under the same heading.
Item 12, WPL 4412 of 2023.
Notice has remained unserved.
You take fresh steps. WPL number 4412 of 23. Notice has remained unserved. Nay, the service report has not been received in spite of issuance of notice by the order dated 5/9/2023. Counsel for the petitioner is directed to take fresh steps for service of notice under speed post, as well as personal service. The requisites be filed by 18th of March. Post this case on 30th April 2024. The affidavit regarding service of notice be filed by 26th April. The office is also directed to track speed post delivery.
Item 13, WPL 6910 of 2023.
ये भी ऑर्डर्स में है. Office does not exist. Respond number 2.
Yet not appear.
Bosch Limited. WPL number 6910 of 2023. The learned counsel for the office note indicates that the notice could not be served upon respondent number 2, as the office of the respondent number 2 does not exist at the given address. Counsel for the petitioner prays for and is granted time till 16th April 2024 to take fresh steps for service of notice upon respondent number 2 at their present and correct address. Personal service लेंगे? The requisites we filed by at his present and correct address. Thusly, in addition, the notices be issued through speed post. The office is directed to track speed post delivery. Post this case on 11th of June, awaiting service report.
May I say one thing? Taking pendency of the REIT application.
Then please hold on. Please hold on for some time. You get the notice served.
Passover case from supplementary list item 2, WPL 800 of 2022.
In this case, Your Lordship, we have challenged the order passed by the London Labour Court, wherein the Labour Court has negatived the claim of the petitioner to the extent Provident Fund amount, gratuity amount, other benefits to which the petitioner was entitled cannot be paid to her. The husband of the petitioner had been working as a khalasi in the Bokaro Steel Limited. He was dismissed from his services on the ground of habitual absenteeism. The matter was challenged before the tribunal. Award was passed, wherein the order of dismissal was set aside, and although he was to be reinstated, but because he had already passed away, therefore, back wages 50% till the date of his death that was given, and other benefits, consequential benefits to which the workman would have been entitled was also given in the said award. Now for quantification of that amount, what is the amount to be paid to the husband, Your Lordship? For that, an application under section 33C2 of the Industrial Disputes Act was submitted, and that has been negatived, although a part of the same has been paid. For that we have come before this Honorable.
So quantification under the Payment of Gratuity Act, there is a specific forum for that.
Your Lordship, may please just have a look to the statements that we have made.
No, the impugned order indicates that they have not entertained this.
That is a completely wrong notion of the Learned Labour Code.
Is it based on some judgment?
Yes, Your Lordship, we have given the judgments.
No, where is the judgment on the basis of which such finding has been recorded?
No, he has only stated, Your Lordship will please see.
The quantification under Payment of Gratuity Act is a self-contained code. You have to, the payment authorities under the Payment of Gratuity Act has the necessary jurisdiction to quantify.
Please,
not under section 33C.
Please just have a look to the words of section 33C2. What is the amount to be quantified by the Labour Code? Please see the exact words, and we have given categorically as to what is to be given.
And there are disputes also in connection with this.
There is no dispute. Everything has been admitted
This is
by
admitted?
the... Yes.
Where is the response of the respondent?
Your
You say
Lordship
it
will
is an
please-
admitted
yes.
amount?
Yes, Your Lordship will please. Please just have a look to our application. Everything has been given in detail.
Where is their reply? Your application you must have given, but you say that it is an admitted amount. Kindly demonstrate that it is an admitted
Yes,
amount.
Your Lordship.
Where is their response? There is a direct judgment of State of Punjab versus Labour Court Jalandhar. That 33C2 will not lie so far as Payment of Gratuity Act is concerned. It's a self-contained court.
Yes, Your Lordship will please
How
see.
do you overcome that judgment?
Yes, we have given the judgments of the Supreme Court.
Yes, I am talking about the judgment of Supreme Court only. That has
Yes,
been
Your-
overruled.
Your Lordship will please see.
Yes. First, you tell us that it is an admitted amount.
That is in the order under challenge itself. Please just come to page number 85.
Yes.
From going through the oral, the second paragraph, from going through the oral as well as documentary evidence adduced on behalf of the applicant and also from perusal of the award in the reference case number 3/2003, the amount of gratuity has not been quantified in the said award. Only the quantification has not been done. But
It is just consequential relief.
in these circumstances where dispute exists in regard to the basis of claim for payment of gratuity, in my considered view, that the said claim under sections 33C2 of the ID Act is not maintainable. So far claim for Provident Fund is concerned, I find here that the workman was out of the rolls of the OP company from 19/6/99 to 6/5/2003. Therefore, there was no any contribution towards his PF account. Apart from that, the claim of the PF amount can be made as per the provisions of the said Act. On the basis of the above discussion, I find here that the claim for gratuity amount worth rupees 1,30,000 and claim for Provident Fund amount worth rupees 3,60,000 can be made by the applicant according to the provisions of the said Act and not under sections 33C2 of the ID Act. However, the applicant can approach the opposite party for their claim of gratuity and PF amount. I have also gone through the judgment such and such. Now to this, your Lordship will please see what we have stated. That is at page 29, paragraph 36. That the petitioner in the claim petition made a claim of the Provident Fund amount not paid to the petitioner while annexure D after reinstatement of the workman Bhanu Rajwa and all the papers relating thereto, which ought to have been forwarded to the EPF commissioner concerned, it was withheld, and as such this statutory benefit which could be computed in terms of money was also made due to the default of the employer, since all these come under the terms consequential benefits as awarded by the respondent number 1. That any money, what is any money, your Lordship, as described under sections 33C2, that also we have stated at paragraph 37, that any money or any benefit which could be computed in terms of money comes under the ambit of section 33C2 of the ID Act 47, which are briefly stated as follows: pre-existing right, existing right, claim under chapter 5A and 5B of the ID Act, right flows from settlement, agreement, award, statutory rights which bonus, provident fund, gratuity, which are part of the award, granting consequential benefits. Right which is incidental to and for the determination of the right under section 33C2 of the Act of 47, while Apex Court decision still holds the field. AIR 1964 Supreme Court 753, Central Bank of India. That the respondent number 1 has willfully overlooked or held per curiam that the award of the respondent number 1 has given right to receive 50% of back wages only and not along with consequential benefits, which award has also been given its implementation by the respondent was their own document M1, wherein the respondent admitted to pay not only 50% of the back wages but EL and HPL subject to maximum accumulation of 30 days in a year, which was the claim of the petitioner while Annexure 1, but it has also been denied, although no such documents as regards EL, much less any calculation in control was filed by the respondent number 2. Therefore, the order is a nullity as the claim under Annexure A is payable, being his existing right. Further, it is expressly perverse to hold that wages constitute only basic plus DA, which is absurd, while Section 2 bracket RR of the ID Act 47, apart from other text, the term means all remunerations capable of being expressed in terms of money and not basic plus DA. This is why the 8448 FLR 310 Supreme Court and 1992-65 FLR 279 that the claim for bonus can be tackled under Section 33C2 of the ID Act 47 since it is statutory payment and comes within the scope of the award, granting consequential benefits, while 1992-48 FLR 310 Supreme Court and 92-65 FLR 289. This position has not been
You are just reading your petition. That does not serve any purpose, no?
with the judgments of the Honorable
So
Supreme
where are the
Court.
judgments?
Yes, Your Lordship, we will give the copies of the judgments.
When you cite it, I am hearing you only.
We have already stated.
You have stated means what?
Means, Your Lordship, that provident fund and gratuity amount.
No, cite the judgments you want to cite. It just can't be just mentioned in the petition and you want us to go through it. It can't be like this. You have to place the judgments you want to cite.
Then, Your Lordship, may please just have a look to paragraph 41. Categorically, we have stated.
No, you have only stated referring to judgments, but you are not citing any during the course
We
of
will
argument.
give the judgments, Your Lordship.
You cite it. When do you want to cite it?
Tomorrow.
WPL number 800 of 2022. Heard Mr. Mahesh Tiwari, Learned Counsel, appearing on behalf of the petitioner. The Learned Counsel submits that he shall cite the judgments tomorrow in support of his case. Post tomorrow. You also cite the judgments regarding scope of 33C2. Respondent is absent. You have served copy on the respondents?
Respondents, Your Lordship. You have not served the copies.
That's your problem. I just don't know. You don't have any standing counsel for Steel Authority of India.
Bokaro Steel City.
You don't have standing counsel here. You can serve them copy if you want to.
From daily list of fresh planning item 14, WPS 2970 of 2020.
Challenge the award because in fact this matter related with the working judges act and we like the Malaysia we go to Malaysia. And in fact what happened in this matter was that if there is a legitimate due and if admitted due under such condition according with the section 17 clause 1 of the working judges act, if it is required to file the certificate case, state government can issue the notice and certificate case. But if there is a dispute on the part of the management under such condition, according with section 17 clause 2 of the working judges act, matter is required to refer before the London Labour Court to adjudicate the matter. And accordingly, since there was a dispute with regard to the self-claimed amount of the claimant,
The matter was referred before the Labour Court to adjudicate the matter. And the London Labour Court, without considering the Majetia Wage Board in a true spirit, what is the Majetia Wage Board recommendation says about, the passed the self-calculated amount of the claimant, and accordingly, award has been passed in favor of the claimant. I have challenged the said award in this writ petition. What is the
What was your written statement?
my written?
Where is your written statement?
I am also reading their written statement and my written statement.
First, you read your written statement.
Yes. Since paragraph 30, para number 6, उसके पहले 40, that paragraph 5, that the claimant claiming himself to be non-journalist newspaper employee filed a claim under section 17 clause 1 of the working journalist and other than hereinafter. The said claim of the claimant is primarily based on the benefit of majority of equity competition made under section 13C of the Working Journalist Act. It is submitted that the claimant was strongly satisfied with the management company during the period of his separation from the service. Because
Where is your dispute regarding calculation?
dispute is very important. Lordship, I am just passing the majority of equity recommendation because this is very much important.
It was exhibited?
No, this is not. In fact, this is over the side. This is over the side.
No. Was it exhibited before?
No, this is not exhibited.
If it is not exhibited, we will not take into consideration.
No, because majority of equity recommendation.
Is it a statute?
A recommendation.
No.
This is also.
No. Please don't tell us this. Things which you have not cited before the learned court.
No. Even the Labour Court had decided only on the basis of the majority of equity recommendation.
It must have been cited. Then only the question of deciding on the basis of
majority of equity recommendation.
It must have been cited.
It is required. Yes, my lord, then I may file by way of supplementary affidavit.
What will you file supplementary?
Because entire main issue is what? That in terms of the Working Journalist Act, with regard to the newspaper establishment, Working Journalist Act is available.
No. What is your point of law? You just tell
Point
us.
of law is what? That the newspaper establishment.
Yes.
There is a terms of reference that the whether such and such amount is due of the said employee against the Hindustan Media Venture Limited of Ranchi unit.
So this is the terms of reference.
This is the terms of reference.
What is your case?
My case is what? That the majority of your recommendation state that there is a requirement to have the average gross salary of the financial year 2008 and 9, 10, 11. If there is there are 8 clauses at paragraph 6 of the majority recommendation. Accordingly, classification had been decided. If one is having more than 1,000 crore of the revenue, under such condition they may fall in class 1. If one is even below 1 crore revenue, they shall fall under class 8 of the said category. And there is a group wise, and there is a group of also of the working in the media house. This is also been grouped that the deputy manager fall in his group. So there is a table in majority of your recommendation. And according with what is the main issue of finding is what? That the Labour Court has considered the revenue of entire company. Though according with the majority of your recommendation, I shall fall if one employee is working in Ranchi unit. Under such condition, revenue of Ranchi unit should be considered, not the revenue of the entire company should be considered. And that is the reason there in the majority of your recommendation, there is a provision of stepping up. If certain unit is falling in suppose class 6 category, class 6, under such condition, his salary shall be calculated from by stepping up.
There is a consideration of this aspect in the impugned order.
It has not been considered. In fact,
it has been considered.
No, it has not been considered. No, it has not been considered. They have, according to the Labour Code, that if your company entire revenue is more than 1,000 crore, under such condition, the benefits shall be the wages shall be calculated from the class 1 category, not from the class 6 from where Ranchi units does fall. So this is the main issue. So even it is also against the 19th clause, 1 clause A and
this aspect has not been considered.
No, it has not been considered. That is.
You don't read your brief.
Yes.
Time नहीं मिलता घर में brief पढ़ने के लिए.
No, I have gone through.
You read. You read. I'm telling you where it is. Issue number 4.
Yes, I'm going.
Kindly read. Specific issue has been framed.
Yes.
Whether newspaper establishment means newspaper establishment of Ranchi unit or
No.
pan-India establishment of. And you say it has not been considered.
No. Issue was framed, but it has not been considered.
It has been considered.
No, what I am saying.
You read the impugned order.
Yes, I have.
You are arguing without placing the award itself.
No.
And you are saying that this aspect has not been considered.
No,
You read it.
It has been considered, but the Ranchi unit has been held that it shall be at par with the Pan India.
That is, it is one thing to say not considered.
Yes.
It is another thing to say no, wrongly considered. Right?
Yes.
So be very, very careful in choosing words. Once
Yes,
you say
yes,
it is not
yes.
considered, the award becomes perverse.
Yes.
But once it is considered,
But again.
you know what
Yes,
is the scope.
Yes. Of course, lawyers should be particular about the choosing of the word. I have not chosen the proper word. That it has not been considered. It has been considered. But
I'm saying so because your clients might be hearing you. How prepared you are. And they can hear it anytime they want to.
Yes, anyway.
So it has been considered. You show us what is the perversity.
It has been considered, but it has not. What is the true spirit of the Malaysia recommendation? It was not been wrongly been interpreted. Wrongly been. That is the reason I am given the wrongly been interpreted because.
How wrongly?
Because even in the.
No, you just see.
Your
It has been considered full text.
Coordinate bench.
Which coordinate bench has decided this?
Not decided. In fact.
आप सीधे कोऑर्डिनेट बेंच पे पहुंच जाते अवार्ड पढ़ते भी नहीं घर में यहीं पे शुरू करते बोले और जो सवाल पूछिए नॉट कंसिडर्ड
In fact, I am fairly 17 that proper word I am not using that not it has been considered but wrongly considered that the revenue of all over India shall be considered.
Why it will not be considered? Are you not catering to the entire need of the entire nation?
No, I am coming not because that is the reason stepping up
ये
provision.
क्या है ये कोऑर्डिनेट बेंच का क्या होगा
Coordinate bench in where notice was issued, stay was granted, and of course this matter has been settled with the terms of compromise. But initial stage.
So why do you want to file this?
I am just showing.
If it has been settled, you settle this also.
I may settle. I may also settle. Everything has been considered in this.
You are not able to present your case properly, you file your written notes.
No, my lord, I may forget.
No, I'm not. You say you have not even read the brief. You don't know. Considered, not considered, wrongly considered. You make no distinction between these words.
Yes.
Which I am not able to, understand that how an advocate can make no distinction between these words. ऐसे बाय डिफॉल्ट नोटिस नहीं होता है यहाँ
नहीं ठीक है बाय डिफॉल्ट
कब करिएगा कब तक रेडी हो जाइएगा हाउ मच टाइम डू यू नीड टू गेट रेडी
मंडे
देयर इज अ रीसेंट जजमेंट ऑफ मुंबई हाई कोर्ट आल्सो देखे हैं वो देखते ही नहीं है कोई मतलब ही नहीं है देखने से
नहीं मुंबई हाई कोर्ट बट
इसीलिए बोल रहे हैं इसीलिए आपको टाइम देगा
because if you go by the judgment of Supreme Court of 1995
हम बताइए कौन सा जजमेंट यू वांट टू साइट
1995 there are two judgments one
Yes.
judgment of 1958
1958 38 58 AIR
yeah and one another
Supreme Court page number
I may give the
page number
paragraph 244
page number
sorry nice citation is AIR 1958 Supreme Court 578
578
78 and
Again?
one another is 1995 supplementary for SCC 758
क्या बोलते हैं?
Yes, it has been dealt that even if there is a common control, despite revenue of entire nation is not required to be considered. Because suppose I want to open one establishment unit in Chakla.
WPL number 2970 of 2020. The learned counsel for the petitioner has submitted that while calculating the awarded amount, the learned court has taken into consideration pan-India figure, although it was required to be confined to the revenue of Ranchi unit only. He submits that merely because there is a control, there is a nodal control, common control, the same is not sufficient to award any amount on the basis of pan-India revenue only. During the course of argument, the learned counsel has relied upon judgments passed by Honorable Supreme Court reported in AIR 1958 SC 578. दिखाइए कहाँ नीचे? As well as 1995 supplementary within bracket 4 SCC 758. You will file your counter affidavit or you are formal party?
We'll take instruction on this.
Issue notice to the respondent number 3 for which requisites under speed post as well as ordinary process be filed by Monday. The respondent number 2 shall also seek instructions and file a counter affidavit in this case. Let the records of the reference case number 23 of 2017 which has been disposed of by the award dated 28/8/2019 be called for from the court of learned presiding officer, Labour Court, Ranchi. Post this case on May. Awaiting service report. Office to track speed post delivery.
Lord, in one matter, Lordship are directed to file counter affidavit of the Chief Secretary in the case. So I may be permitted. In that matter, a senior advocate is present from Patna.
What counter have you filed?
The Chief Secretary convened a meeting with the other secretary as per your Lordship direction, and he filed that the post is
Equivalent. The matter is coming up tomorrow.
Tomorrow.
They may need to file a response to it.
And we shall also respond to the final argument of the learners.
You have also responded to that?
I have to respond because the argument has not been.
What happened to the plea taken in your counter affidavit that the matter has been you are seeking guidance from other states? Why are you seeking guidance from other states?
That was not proper. That's what the Chief Secretary has filed.
We'll take care. Mr. Clerk, did you go now?
कल है
फाइल कर इसको ठीक से रखिएगा सारे जजमेंट्स हैं